recent Kerala High Court ruling has triggered a big debate in the country, a debate between laws and tradition. What should take precedence if it is a fight between constitutional rights and religious freedoms? In case of marriages in the Muslim community, the Kerala High Court has now ruled that a Muslim man's second marriage cannot be registered under the Kerala Registration of Marriages Rules of 2008 without notifying and hearing his first wife. The court observed that constitutional mandates must be respected when a Muslim man wants to register a marriage. The first wife cannot be a silent spectator. The Kerala High Court also observed that constitutional rights cannot be ignored in the name of religious freedom. Gender equality is not a woman's issue, it is a human issue. Let me go across to Dipankar, my colleague. He is getting us more from what the Kerala High Court said. Dipankar, take us through what the court said today. This is a significant direction coming in from the court as far as women's rights is concerned.
Well, yes, the Kerala High Court has very categorically stated that when there is the first wife who's living, then the registration of a second marriage cannot be done, and has very clearly and categorically stated that the constitutional rights are supreme, in the way that when there is a marriage that has taken place, that has been solemnized, and after that a second marriage takes place, then the view of the wife, if she's creating some kind of obstruction, if she's raising some kind of argument stating that the second marriage is invalid, that has to be taken into consideration. This was the observation of the court when a Muslim man had approached the Delhi High Court, the Kerala High Court, where he had challenged the decision of the registrar, and while rejecting his petition, the observations were made by the Kerala High Court that if any contention is raised by the first wife while the registration of the second marriage is being taken place, then that has to be taken into consideration, and that has to be taken into consideration specifically by the courts rather than the registrars or any other place. It has to be taken into consideration by the courts. These were the very essential, very categorical statements, observations that were given by the Kerala High Court.
All right, Dipankar, I'm going to come back to you. Stay with us. Let's also get our viewers how the BJP has reacted to this. The BJP has targeted the Congress party, reminding them of the Rajiv Gandhi era when the landmark Shah Bano judgment was overturned. The Supreme Court judgment protecting Muslim women's right to maintenance during talaq or divorce. The BJP leaders have said that while Rajiv Gandhi as the Prime Minister surrendered in front of Muslim hardliners, Prime Minister Modi brought a major reform for Muslim women by abolishing triple talaq.
देश के अंदर राजीव गांधी जी देश के प्रधानमंत्री थे, तो सर्वोच्चतम न्यायालय का फैसला बदल दिया गया केवल छद्म धर्मनिरपेक्षता और वोट बैंक की राजनीति के लिए। तुष्टीकरण की पराकाष्ठा हुई और देश की बेटी धर्म के आधार पर बांट दी गई। लेकिन आज प्रधानमंत्री मोदी जी ने वो वातावरण दिया है कि आप खुलकर बता भी सकते हैं, कह भी सकते हैं और ठीक भी कर सकते हैं। 2017 में प्रधानमंत्री मोदी जी ने ट्रिपल तलाक की कुप्रथा को समाप्त किया।
All right, so that is the tussle between the BJP and the Congress. Remember, a significant direction coming in from the Kerala High Court as far as the first wife of a Muslim man is concerned. They've said he cannot go ahead with his second marriage until and unless the court has heard what the first wife has to say. A clear mandate that has been given by the Constitution.